Alam po ninyo sa mga litigation lawyers, practicing lawyers worth their salt. Wala ka lang certification of non-forum shopping, i-dismiss ka ng Supreme Court. Maliwanag po yun. Hindi subscribe yung complaint mo, dismiss ka kagad. Mahigpit po ngayon. Ito po, this is an impeachment complaint. You are removing the second highest official of government. Yun lamang pong verification. Sablay na po.
Mabuhay Pilipinas at mabuhay kayo. Pakinggan natin ang palitan ng motion isa laban sa 4 na senador. Kung bago ka pa lang sa aking channel, huwag kalimutang mag-subscribe, mag-likes at hit the notification bell para laging updated sa sunod nating i-upload na mga videos.
Pwede pong tratuhin pala ngayon sapagkat wala pong verification. It may be treated as an assigned impeachment complaint. Paano ngayon? Pagkat magsasalita po ang napakarami. Alam po ninyo kung, Mr. President, kumbaga po sa nagluto ng sinaing, pasensya na po kayo kung kinakailangan ako po'y gagawa ng pagkahalin tulad, ano. Ang impeachment complaint po ay parang sinaing na niluto ng House of Representatives. Hilaw po Suprema na, kailanman ay huwag kayong mag-impeach, huwag na kayong mag-file. Ayusin nyo lang po Yun lamang po ang gustong mangyari dito. Ayusin nyo. You want to impeach the Vice President, do it in the right way. Hindi naman po tinignan ng merito Ang sinasabi yung proseso, hindi po nyo sinunod Sinasabi na nga, walang impeachment complaint bukod sa isa. Laban sa isang opisyal sa loob ng isang akalain mo namang 4 po kagad ang ipinay. Pagkatapos yung 4, i-consider mo na isa. Hindi naman po yata tama yun, Mr. President. So the Supreme Court has already spoken. The last arbiter of law. It says the complaint is unconstitutional. It's void ab initio. It's violative of due process. The Senate never acquired jurisdiction over this. It is immediately executory. On that note, Mr. President, I respectfully move that the impeachment complaint be dismissed. I so move, Mr. President.
So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR, or the motion for reconsideration filed last Monday by the House of Representatives. Is it not, Your Honor?
The question whether is it...
Yes, your
subject
basis
to
for
appeal?
your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor. That's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final, thus appealable. Ngayon, naka-apila na. Marami nagtatanong, kung naka-apila na, ba't tayo nagmamadali? Na-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess. Because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo, meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babalik rin po nila yung kanyang sarili. Kaya napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone, the reversal of the Supreme Court's own decision is not impossible, even in landmark cases. in the case of Labugal, Bilaan Tribal Association Incorporated versus Victor Ramos, GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR, reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lily Lopez versus Lolito Lopez with GR numbers 25497-957-58. So, may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi niyo, unanimous decisions po ba lahat?
I am not sure about that. But one thing I can say is that if there is a mistake, unanimous decision could become a unanimous mistake.
Wala pa pong nangyaring gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ang kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-tahasang hukuman na gumawa ng paraan para isang tabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, not because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question, but then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Canal Rock has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, "The House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress." To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with a sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. The treaties, bills, resolutions, anything filed continues. It is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mga lipa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw. Hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related, the Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This third and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the third mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? The constitutionalists or CONCON delegates Munsod, Ascuna, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun eh. I've read that the basis for the retroactive application of the new definitions because the Senate now has not acquired jurisdiction yet. Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe ba kayo? You even sent out summons. Ano yun? June 9, the Senate President took his oath. June 10, nag-convene ang impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense. Ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, but several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off-topic, sabi nila. Para bang pinagtagpi-tagpi. Basahin niyo mabuti. Uli, ang daming gagaling ng mga abogado rito. Basahin niyo. It even quoted the entire Article 11 of the Constitution not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this present impeachment case is of no moment to me. The Vice President is a friend of mine. The former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leoded himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly have the right to call attention to the fallibility of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwede mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, it is a unanimous mistake. That again can be corrected by setting aside and reversing prior pronouncements. Again, they have filed, the HRP has, the Office of the Solicitor General has filed the MR last Monday. So, in this regard, we shall wait for the resolution of the MR. Please, let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors for their sake and for the sake of future proceedings. let us not dismiss forthwith. And in that light, considering the motion of the gentleman, to motion to dismiss, I move to table the motion to dismiss. A motion to table is a higher precedence than a motion to dismiss. Thank you, Mr. President.
Ng good gentleman mula sa Tarlac, that in fact, the Supreme Court has reversed a unanimous decision in a lot of instances before. Dalawa lang po ang ibibigay kong halimbawa. League of Cities of the Philippines versus COMELEC. Original decision, 2008. Reversal on motion for reconsideration, 2009. Isa pa pong halimbawa, International Service for the Acquisition of Agri-Biotech Applications, Inc. o ISAA et al. Versus Greenpeace Southeast Asia. Original decision, unanimous, December 8, 2015. Reversed unanimously on MR din, July 26, 2016. So, hindi lang po tulad nung sinabi ni Minority Leader na there's always a first time, it has happened before. So, yung ganitong klaseng milagro na hinahanap, posibleng mangyari din po dito sa kasong pinag-uusapan natin. Malay po natin. Salamat po, Mr.
Noted.
President. Salamat
Mr.
sa good
President,
gentleman
may I know
from Tarlac.
from the
Entered
good
into the
senator,
record. Senator Marcoleta.
may I know from the good senator if these decisions are bank decisions or divisions?
Yes, Mr. President, unbanked decisions po.
Well, you have to cite the
I would gladly
jurisprudence.
cite the GR number po bang hinihingi, Mr. President?
Pagka sinabi pong bank, lahat po ng members ng Supreme Court, 15 of them, unanimous.
To
Kasi po,
reiterate what I...
baka division lang yan, 5 lang yun. Hindi po
No,
bank
Mr.
yun.
President, to reiterate what I already said, mga ano po ito, mga reversal ng unanimous Supreme Court decisions.
Yes, but I am
At sa
asking for
dalawang
qualification,
halimbawang
Mr. President,
binigay ko
whether
po
these are
on
bank
MR.
decisions or decisions by a division. And whether or not they
Mr.
were
President,
characterized by...
sinabi ko rin na po kanina,
Sandali
unbanked
po.
decisions po ito. Hindi po,
Whether or
I
not
am
the
replying to the
decisions
question.
are characterized by the following qualifications. 1, unconstitutional, void ab initio, violative of due process. All these are present in those jurisprudence and cases as you cited.
Mr. President, bagamat para itong yung pinag-uusapan natin kaninang operative facts, kanina, simple lang yung tanong eh. May kaso na po ba na ang Supreme Court sa unanimous decision ay ni-reverse ang sarili nila? Ngayon, may dinadagdag na tanong. Pero sige po, yung League of Cities of the Philippines versus COMELEC, the Supreme Court, in its original decision in 2008, unanimously declared the cityhood laws unconstitutional. I will have to get more information po on the ISAA, reversal of unanimous decision. Pero malinaw na mga sagot na po ito dun sa original na tanong. So the original assertion na hindi po natin alam kung na-reverse na ng Supreme Court ang sarili nila sa original na unanimous decision has fallen by the wayside. Kasi the Supreme Court, as I said already earlier, has reversed a unanimous decision unbanked in a lot of instances before. Yun lamang naman po, Mr. President.
Noted and entered
Salamat
into
po.
the records.
ng mga kapwa nating senador ay sumasang-ayon po tayo at tama, no? Napag-usapan na po ang independence ng Senado, kung gaano kahalaga ang papel na ginagampanan natin sa ating bansa, sa checks and balances ng ating gobyerno. At alam rin naman po ng mga kasama natin na sa caucus, sinabi ko rin po na ang posisyon ko ay dapat mag-convene ng impeachment court at doon magdesisyon kung ano ang mga susunod na hakbang pagdating po sa impeachment case. No? That's known to everyone. I've said that in the media. Mr. President, in our history, nagkaroon po ng mga panahon na ang Senado ay nag-assert ng kanyang independence bilang isang co-equal branch of government. Nangyari po yan many times. I remember in the 90s, kahit po ang executive, at that time, President Cory Aquino, nagnais na manatili ang US bases dito sa ating bansa. Yung Senado, nanindigan. Kahit puro kaalyado, kahit puro kakampi at kamag-anak nasa Senado, nag-decide pa rin yung Senate to assert its independence and to do away with the US bases. Nangyari po yan many times in our history, Mr. President. Kaya palagay ko, yung role ng Senado napakahalaga pagdating sa pagpapanatili ng checks and balances. And Mr. President, marami tayong tungkulin. May tungkulin gumawa ng batas, may tungkulin sa pagbuo ng maayos na budget, may tungkulin ng oversight, pero meron din pong tungkulin pagdating sa pananagutan or accountability. At yun po yung sole power to try and decide all cases of impeachment. Ang posisyon ko, Mr. President, at nabanggit rin ito ng iba nating mga kasama, ay mahalagang i-assert natin ang ating independence. Mahalaga po na itong papel na ginagampanan natin sa ating Constitution ay pahalagahan po natin. Mahalaga po na manatili ang independence ng ating Senado bilang isang co-equal branch of government. Mr. President, posisyon ko rin po na nagsimula na ang impeachment proceedings. Nag-robe na po, nagsimula na, merong summons na binigay, may response na po si Vice President Sara. Kami pong mga bago, may mga robe na rin po pero hindi pa po nadudumihan, hindi po magagamit, no? Ang posisyon ko po, mag-convene ang impeachment court at doon natin i-decide ang mga bagay-bagay na ito. Mr. President, may dalawang bagay rin na nailabas, no? Na hindi pa siguro na pag-uusapan. Let me read, Mr. President, Article Article 9, Section 3 of our Constitution, accountability of public officers. In case the verified complaint or resolution of impeachment is filed by at least one-third of all members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Wala pong dagdag po dito. No? Dito po sa gallery, kasama ho natin dalawang framers of our Constitution. Nandito po si Professor Ed Garcia at si former Chairperson Christian Munsod. Kanina po, nagbubulungan kami. Sabi ko, nung ginawa nyo to, bakit parang ganun kasimple? Simpleng-simple lang, ito lang. At sabi nga po nila, noon daw, 1/2, 2/3, binabato 1/2 sa deliberation, nag-end up sa 1/3. At yung desisyon ay dahil sa kabilisan. Dahil mahalaga daw na mabilis. Pag may 1/3 members of the House ang pipirma, mabilis na pupunta po sa Senado. At ito po, tinatanong ko sa kanila, dahil sila po yung nagbuo ng ating Constitution. You know, many times, Mr. President, umiikot tayo sa ating bansa. I-bring up ko lang po yung free college law. No? Marami ko sa atin dito nagtulungan para sa batas na yan. Meron kaming nakausap na eskwelahan. Ini-explain sa akin yung opt-out provision. Kung paano sila nag-charge ng mga estudyante dahil sa opt-out provision. At sabi ko sa kanila, mali. Mali ang interpretasyon ninyo. Yung interpretasyon ninyo, wala yan sa aming intensyon. Ang intensyon po namin, libre ang kolehiyo sa mga kabataan. At nung nag-argumento po sa akin, ang sabi ko, mas alam ko yan kasi ako ang nagbuo ng batas na yan. Mas alam namin yan dahil kami ang nagsulat ng provision na yan. In the same sense, Mr. President, the framers of our Constitution, mas alam po nila. Mas alam nila kung ano yung intent ng ating Constitution. Wala pong labis, walang dagdag. Many times, Mr. President, tinatanong tayo, usually, pag campaign time to, tinatanong kami, Mr. Senator, hindi ba dapat merong educational attainment requirement yung pagiging senador? At sinasabi ko po lagi, wala, kasi wala po yan sa ating konstitusyon. Wala pong dinagdag, wag tayong magdagdag nang wala pong nakasaad po dyan. So gaya po niya, no, binabanggit ko lang po dito, dahil na pag-uusapan, may mga dinagdag na mga procedure. Alam ko po, siguro, tama po ang sinasabi ni Senator Marcoleta, baka maganda naman ang intensyon ng Supreme Court. Pero aminin na po natin, wala po yung ibang mga bagay dyan dito po sa ating konstitusyon. Pangalawang punto, ito po, hindi rin po napag-uusapan pa. Nabanggit po dito, wag na tayong lumaban kasi matatalo rin naman tayo. No? Of course, Mr. President, it is improbable, aminin ko po yan, very improbable na magbago ang Korte Suprema with 15 votes. But it's not impossible. Improbable at impossible, magkaiba po yan, firstly. But secondly, Mr. President, may mga panahon na kahit alam nating matatalo, kailangan pa ring lumaban. Tayong lahat po dito, dumaan po dyan. Ako po, dumaan rin po dyan. Kahit mukhang mahirap, kahit mukhang matatalo, kailangan lumaban pa rin. Tumayo tayo sa sarili nating paa, mag-assert tayo ng ating independence, ipahiwatig natin yung ating saloobin bilang isang grupo, ipakita ho natin na co-equal branch of government tayo, na meron tayong punto de vista, at kahit matatalo, kahit sa kaduluduluan ng lahat, respetuhan rin naman natin ang Supreme Court, mahalaga na mailagay pa rin kung ano ang nasa saloobin ng ating grupo. Mahalaga pa rin na malagay natin kung ano talaga ang posisyon ng Senado pagdating sa ating independent nature and being the sole authority to try and decide impeachment cases, kahit po matatalo. So para sa akin po, hindi katanggap-tanggap ang posisyon na dahil matatalo rin tayo, huwag na tayong lumaban. Paminsan-minsan po mahalaga na ilagay naman natin ang ating posisyon kahit alam po natin na hindi pabor sa atin ang mga bagay-bagay. Thank you, Mr. President.
President, this is not an interpellation, but with the permission of the gentleman from Tarlac, we will just make a manifestation.
The gentleman may proceed.
Thank you, Mr. President. Mr. President, marahil marami ang nagtataka o nagtatanong, ano nga ba ang pinakapunot dulo o debate na pinag-uusapan dito sa Senado? Tatlong probisyon ng saligang batas. Tatlong kapangyarihan ng tatlong sangay o tatlong governmental entities. Yung kapangyarihan ng judicial review ng Korte Suprema, yung sole power ng House of Representatives to initiate impeachment proceedings, at yung sole power ng Senate bilang impeachment court para litisin at pagpasyahan ang isang impeachment case. Narito tayo ngayon, nagdedebate dahil yung judicial review power ng Supreme Court ay pinawalang bisa ang sole power ng House of Representatives para ito ay mag-initiate ng impeachment proceeding, at pinawalang bisa rin ang kapangyarihan ng Senado bilang having the sole power to try and decide impeachment cases. Dahil dito, saan tayo tutuloy? Merong na rin mga ruling ang Korte Suprema kung paano natin iha-harmonize o ihahambing ang mga nagtatalong probisyon ng saligang batas. Sinabi ng Korte Suprema sa kaso ng Civil Liberties Union versus the Executive Secretary, pati na rin sa Francisco case versus HOR, the Constitution is to be interpreted as a whole, and one section is not to be allowed to defeat another. In this case, the judicial review should not be defeated. The sole power of the House to initiate should not be defeated. And the sole power of the Senate to try and decide cases. All mandates, all duties all constitutional powers that do not belong to us, that was given to us not by any whim, but by the Constitution, all of whom here sworn to uphold and defend. Kaya ano ang way forward? Sabi nga, may mga minungkahi, si Justice Ascuna, hayaan sa MR, payagan, sa motion for reconsideration, payagan na magkaroon ng operative facts doctrine para yung anuman ang pinagpasya ng Korte Suprema sa kasong ito should apply prospectively, number one. Pangalawa ay sa pamamagitan ng MR pa rin ay mabigyan ang House of Representatives na maituloy ang kanyang kapangyarihan to initiate, and at the same time, mabigyan ang kapangyarihan ng Senado to try and decide the case. Kaya habang naririyan ang MR, baka sakali, at nangyari na nga, na the Supreme Court has reversed itself, even in a unanimous decision. But even assuming it does not reverse itself in this case, the Supreme Court may modify its ruling. And therefore, if it modifies the ruling, assuming that it modifies but does not reverse itself, should we not await the resolution of the motion for reconsideration before we vote today? We hold it in abeyance or we table it. Mr. President, if I may add, the SC, the Supreme Court, hindi niya binanggit. Binanggit niya nawalan ng jurisdiction ang Senate Impeachment Court. Pero ang ibig sabihin nun ay pinawalang bisa, ginawang void ab initio ang mga kilos at pasya ng Impeachment Court. The convening of the Impeachment Court was voided. The majority decision to remand the complaint to the HOR was voided. The summons by the Impeachment Court were all voided. Which brings us to the question, who now is deciding the impeachment case? Now that all the decisions of the Impeachment Court have been voided. It's a tricky question, Mr. President. But if I were to be an impeachment court judge, I would argue that we have to, in the MR, in the motion for reconsideration, intervene and uphold the impeachment court's exclusive power to try and decide the case. Why? Because it is the constitutional duty to do so. It is the order of the Constitution. We are not defying the judicial review powers. We are upholding the sole power of the Senate to try and decide impeachment cases. But having said that, sabi nga, it is our view, and this is shared precisely by former Supreme Court Chief Justice Panganiban, former Chief Justice Puno, former Constitutional Commissioner and Justice Ascuna. They have seen, or they have read their decision, and they too have said that the Supreme Court erred on a matter of facts. And if the Supreme Court erred on a matter of facts, how can you be right with the law if you are wrong with the facts? And if you are not right with the law, why will the Impeachment Court and the Senate, for that matter, decide on the matter today? Why not wait for the motion for reconsideration? Siguro naman, hindi natin binabangga ang Supreme Court, hindi natin binabangga rin ang House of Representatives dahil meron ding prinsipyo ng parliamentary courtesy, meron ding prinsipyo na kinakailangan natin bigyan ng respeto ang co-equal. We are a co-equal to the House of Representatives. Ano na lang ang magiging repercussion na ito ang House of Representatives nag-file ng motion for reconsideration, hinihiling nila sa Supreme Court na baguhin ang ilang mga findings of facts, baguhin ang kanilang naging desisyon, habang pinangunahan ng Senado ang House of Representatives at sinabi, wala kaming pakialam sa inyong motion for reconsideration, i-dismiss namin ang kasong ito. I think, out of courtesy for a co-equal, we should respect the House of Representatives. In the same way, if the Senate would, at a future time, file a case before the Supreme Court and seeks a motion for reconsideration in a matter that involves the House, we would like to think that the House will not act to have the case dismissed pending the MR out of respect for a co-equal. Sana, pag-aralan natin ang husto ang pagpasya ngayong hapon. Sabi ko nga, the findings of grave abuse by the Supreme Court, thereby removing or taking away from us the jurisdiction, na wala tayong jurisdiction, that jurisdiction was not acquired on the basis of facts that are flawed, where then is the grave abuse? I don't know what the ruling will be. Perhaps they will say, yes, there was no grave abuse of discretion on the part of the House because of the one-year bar, which was not actually the fourth complaint was not barred, I don't know. But whatever it is, hintayin na lang naman sana natin. Respetuhin naman natin ang ating co-equal. Why the convening of the impeachment court is the way to go? Dahil pag tayo ay bumoto ngayong hapon, ngayong gabi, na i-dismiss ito, aksyonan ang impeachment complaint, we will be acting beyond, without legal authority, dahil wala naman sa atin yung impeachment complaint. Wala namang kapangyarihan ang Senado in plenary, ultra vires, without legal authority, ang magiging desisyon natin. One final point. In the Corona impeachment trial, nang himasok, nag-TRO ang Supreme Court para sa mga bank accounts. Ano ang ginawa ng Senate Impeachment Court? Bumoto 13-10 para respetuhin ang Korte Suprema. I did not vote in favor of the TRO or respecting the TRO. But the Senate, as an impeachment court, voted and we respected it. Because it was the Senate Impeachment Court that decided. It was not the Senate. It was the Senate Impeachment Court that, seeing perhaps that we needed to harmonize the power of judicial review, the power of the Senate as an impeachment court, to have the sole power rather to try and decide cases, seeing that the Senate Impeachment Court decided to harmonize the conflicting provisions of the Constitution. I think we should, as a Senate Impeachment Court, do the same. Kung ipagbobotohan na respetuhin ng Korte Suprema para walang constitutional crisis, so be it. But it ought to be the Senate Impeachment Court that asserts.
Maraming salamat at mabuhay kayo mga kababayan. Ang Panginoon ay laging kasama sa inyo.